Hi, this is Jim Cunningham. I've got Winston Duggan from our firm Cunningham Legal here to talk about crucial estate planning strategies after a divorce. So this is for people, if you're going to get a divorce, if you're in the middle of a divorce, if you've been divorced, if a loved one is going through that. This is very important information, very important to pay attention to. There are a lot of gotchas in here. There are a lot of traps. This is what Winston and I talking today. This is just information only. This is not legal advice, so don't listen to this and go out and do a bunch of stuff. If you're watching this on YouTube, we're doing this live as a live webinar, but this will be on YouTube. Go ahead and subscribe. It's really easy. You just click the subscribe button there and subscribe. And also you can share that with people who might benefit from this. We do have office locations in Northern and Southern California. And this is our team of 7 lawyers at Cunningham Legal, and we are devoted entirely to trust and estate matters. And I'm the CEO and partner at Cunningham Legal, more than 25 years experience. And our firm does help clients in other jurisdictions. We're licensed in Missouri, Texas, Virginia, and the District of Columbia. I'm a certified specialist in estate planning, and this is part of the theme of the book I wrote, which you'll see a slide on that, which is you got to pick the right lawyer. Picking a certified specialist indicates that that's the right lawyer, but because they're practicing and their focus is in estate planning. I'm also a real estate broker, securities insurance, and a pilot. And we have with us Winston Duggan, who's an associate attorney here at Cunningham Legal. And I'm proud to be able to be doing this with you today, Winston. Super excited. You graduated from Santa Clara University, and you have your BA in political science, law, and politics from Marquette University. And you're committed to helping children and families. And the reason you're here with me today, Winston, is you practice family law for a while and have found that estate planning is really where you want to be. Here's the information on the second edition of our book, Savvy Estate Planning, What You Need to Know Before You Hire the Right Lawyer. Very important, a lot of stories in there. This is what you read before you go visit with the lawyer. And let's talk about, I'm going to tee this up, and Winston, I think you're going to do a lot of the talking here today. But there are some crucial strategies after a divorce or during a divorce. And so what this means is the act of filing the divorce papers begins this divorce proceeding. And a lot of people, as we were getting ready for this, Winston, a lot of people have no idea the effect of divorce on their estate plan and who inherits. The inheritance rights can immediately change. They can change later. A lot of stuff going on here. We'll talk about that. When your divorce is finalized, your living trust, if you have a living trust, winks out of existence. What do I mean by that? Well, once the court finalizes the division of property, it is awarded typically to the divorcing spouses individually. And so that defunds the trust. And if there are no assets in a trust, that trust goes away. And even though they may not be legally entitled to a lot of your stuff, they can end up with it. We'll talk a little bit about how that works. And we'll cover what to do to properly ensure that if you have a divorcing child, that the estate plan is set up properly. So, Winston, I'll let you take it from here. You want to kind of just cover the high-level points here on marriage and divorce?
Yeah, of course. So what we're going to talk about today is the steps you need to take to ensure that your wishes are followed and you and your loved ones are protected. And so just to start with, when we're talking about divorce in this presentation, if you have a registered domestic partner, that is the same as a marriage for estate planning purposes. And by that, I don't mean someone you consider to be your domestic partner. This is a domestic partnership that you have registered with the state. It is considered a marriage. You should also know that when you have filed for divorce, you are still married in the eyes of the law until you get a final divorce judgment. What filing for divorce may have done is established what's called a date of separation, and we'll talk about that a little later. But marital status and the issue of whether or not you are legally married, that is a separate issue in your divorce proceedings. The divorce doesn't become official until marital status terminates. That's usually at the very end of your divorce case, but not necessarily. It is possible to terminate marital status before settling property, support, and custody orders. So I think the takeaway from here is do not forget, even if you file for divorce, you are still married. All right, so in the previous slide, I'd mentioned date of separation. The date of separation is the cutoff date for determining community property versus separate property. Please be aware that this date is not necessarily agreed upon initially. Two spouses can claim vastly different dates of separation, and this can have tremendous consequences in determining what is community property versus what is separate property.
Yeah, Winston, I have a question on that. So when you say there, if a marriage is kind of ending and one spouse says, I'm out of here, I'm going to go stay in a hotel, is that a date of separation?
So I would say, yes, it is mostly fact specific. It's, the date that the marriage went, beyond repair. So if one spouse decides it's beyond repair and they leave, that's usually a pretty good date of separation. But if you are, going to counseling and trying to work things out, you can't say, oh, the date of separation was before we started counseling. Like, no, you were still trying. But yes, one spouse can determine the date of separation if they're the ones that says,
Great.
I'm done with this. So right. So even a small difference in the claimed date of separation can greatly affect the divorce. If one spouse earns a large sum of money in between the two dates, that can have a big impact. And partially because that a claimed date of separation can cause confusions, the court imposes an automatic temporary restraining order, and I'll refer to that as the ATROS. If you are the one filing for divorce, you are subject to the ATROS as soon as you file. And the other spouse is subject to the ATROS once they are served with divorce papers. The terms of the ATROS are on the summons document, which is required to be served with all of the documents when you're going through divorce.
Winston, what if you know that your spouse has filed, this actually came up recently. We got a call from someone who says, I know my spouse has filed divorce papers. I haven't yet been served. I want to change my estate plan.
I wouldn't touch it.
Yeah.
I'm not going to, actively try to get around the law.
Yeah.
It might be within the law, but I wouldn't push that.
And something to understand is if you're talking about death, everything sees the light of day, meaning if you try shady stuff, it's going to come out.
Yeah.
So I would tread lightly on that one. So just because you can do something legally doesn't necessarily mean you should, especially when you've got a lot of judicial discretion and a judge is going to want to do right. I mean, every judge I've met, every single judge, the reason they're a judge is they want to administer the law fairly and justly. And, if you try and work it, you can get slapped pretty hard on that. So let's talk about the ATROS, what you can't do.
Yes. So how does the ATROS affect your estate plan? And I guess I'll start with, please know there are other terms in the ATROS, such as not being allowed to cancel insurance, but we're only going to be discussing the terms of the ATROS as it relates to estate planning today. And so while subject to the ATROS, you cannot dispose of your property without an agreement or court permission. And that is community property, quasi-community property, and separate property. So no transferring money, no funding a new trust, no changing beneficiary designations without a signed stipulation or a court order. There is an exception to that, which is in the usual course of business or for the necessities of life. I consider that to be a very narrow exception. So to be on the safe side, basically just don't touch anything until the court gives you permission.
Yeah, and this comes up fairly frequently in our practice where we'll have clients and they call and something to understand is if you and your spouse have gone to a lawyer to do an estate plan and you go back to that lawyer and say, hey, don't tell my soon-to-be ex, but that's a conflict of interest, okay? And it's something where it certainly can be waivable, but there has to be consent, right? So that, and sometimes this does happen where the spouses are splitting up and they say, well, I don't care if you go back to the lawyer we went to. And that is a thing, but just understand that if you think you're going to go back to your existing lawyer that you had with your spouse, it's likely there's going to be a conflict issue there.
Mm-hmm.
Well, great.
All right.
So what can you do?
So what can you do with your estate plan while your divorce is pending? You can still create a new will. So your soon-to-be official ex can't be or won't be your executor or the beneficiary under your will. You can create a new financial power of attorney. So your ex can't make transactions on your behalf or access bank accounts that are in your name alone. You can make new advanced healthcare directives. So your ex isn't the one who gets to decide whether or not to pull the plug or make other medical decisions. And you can create a new trust, but you cannot fund it unless you have permission to transfer your assets from the court. Sometimes there will be agreements to divide accounts in a certain way while the divorce is pending. So, each party has, money for themselves to spend. And once you have an order for the division, then you can do with that money what you will, but not until the judge gives you the okay.
So what if you pass away while you're married, but you've got this sort of divorce pending? What's happening there, Winston?
So what happens when you pass away when you're married, and whether or not you are in the process of getting divorced, your assets will be transferred according to the terms of your trust or your will. And that's why it's important to update the documents that you can update.
Right.
So what if you don't have a trust or will? Well, that's what's called intestate succession, and who inherits is dictated by the California Probate Code. And it says that if you pass away without a will, your spouse will receive all of the community property and can receive up to half of your separate property, with children or family receiving the other half.
Yeah, and this is really important. So something to understand is if you don't have a will, it's a mandatory determination of what is community and what's separate. And that makes sense because the surviving spouse gets all the community property. And so a court has to decide what's separate and what's community. Basically, community property is everything you acquire during marriage. Separate property is everything that you bring to the marriage or you receive by gift or inheritance. That does not later get transmuted to community property, right? So there's that important issue. So I will tell you, I've been involved in more than one case where there's a big fight over what is community and what is separate property, and it is not clear. France, being France, if you're familiar at all with France, it's kind of like Moscow Central, Paris Central. Everything, it's very strict, it's very rigid, and when you get married in France, you have three choices. Everything's community property, everything you bring to the marriage is separate, but any future earnings are community, and then everything's separate. You just literally check a box, which is, a much clearer way of doing it. I'm not sure it's superior, but it's a much clearer way. But it's important to know that there's no bright line between what is community and what's separate. It's a rather fuzzy line.
Mm-hmm. All right. So what happens if your divorce isn't done when you pass away during the pendency of your divorce case? So again, you are still married and you are still bound by the atros. But I would advise you check your estate plan during the pendency of your divorce. Some trusts have language regarding the termination of the trust or a partial revocation as soon as divorce papers are filed. Now, other trusts only address what happens when the divorce is finalized, and your trust may be entirely silent on the issue. Now, if your trust does address the divorce, it may say once divorce papers are filed, the other spouse will be considered to have passed away. But I recommend look at your document, see what it says so you know what situation you are in. Now, there is an exception, I guess, this a bifurcation, and that is when the divorce is still pending, but you aren't legally married. And so that is called a bifurcation of the issue. And so what they do is they cut it into two pieces. They bifurcate the issue of marital status, and you can terminate marital status separately without having final orders on property support and custody.
Yeah, so the idea there is you can be divorced, but you haven't agreed as to what's community and separate property. So the marriage is over, but you still haven't, and that can go on for years.
Yes, I would say it's relatively uncommon, but it does happen.
Yeah, I would say it happens on larger divorces or more contentious divorces.
Yes.
You see that, and it's just more legal fees. And I'm of an age where people get divorced, and I've had friends reach out to me and I say, you really want to rethink that because you're going to lose 75% if you get divorced because a lot goes to attorney's fees. So here's an example. Hal files for divorce from Wanda in January, and then in February, Hal dies unexpectedly. He's hit by that beer truck or that taco truck or whatever it is. So Hal dies unexpectedly. Hal is filed for divorce. What happens to Hal's assets? If his trust says, and this is a big if his trust says, if anyone files for divorce, then it doesn't go to the spouse, it goes to the kids, let's say. But if it doesn't have that provision in there, then the assets go to Hal's half of the community property, Hal's half of the community property with Wanda, and Hal's separate property goes to the kids. If that provision is in there. If it's not, Wanda gets everything, right? Typically, it's whatever the trust says. And so that means that Wanda may inherit all of Hal's assets, and Wanda may be a really bad apple, right? And Hal may be the one who's a real victim here, but Wanda, Wanda ends up with anything. And again, this is very specific. It depends on what the trust says, but it does not, and this is really important, it does not address assets outside of the trust. And I would say one of the, and sort of what we led with in the description here is sometimes an ex will end up with stuff. How does that happen? Let's say Hal named Wanda the beneficiary of Hal's life insurance policy. Hal and Wanda get divorced. 10 years later, Hal never updates his life insurance policy. What happens when Hal dies? Wanda can go to the insurance company and say, give me the money. Now, it may be that as part of the divorce settlement, Wanda is not entitled to the insurance proceeds, but guess what? She just goes in and takes them, right? Because Hal never updated the beneficiary designation. So that is one example. Believe me, that happens quite often, okay? Somebody forgets an asset, they overlook something. So let's talk about these two. We typically don't talk too much about probate code sections, and not to confuse you, we're not talking about probate, but trusts are under the probate code. So California doesn't have a separate trust code. So when you see the word probate, it's not necessarily, we're not advocating probate, but these provisions about trust appear in something that is called the probate code. So Winston, why don't you take it from here?
Yes. So how does a finalized divorce affect your estate planning? A completed divorce, according to the California Probate Code, automatically terminates non-probate transfers to your ex. So what are non-probate transfers? Things like beneficiary designations on bank and investment accounts, your spouse as beneficiary of your trust, with the noted exception of life insurance policies. Those beneficiary designations, by operation of law, do not change when your divorce is finalized. The probate code also terminates transfers to your ex via your will, which would be through probate. And it also by law removes them from acting as executor, trustee, conservator, or guardian.
Yeah, it's important to note if one spouse, let's say Hal and Wanda divorce and Hal dies, if Hal and Wanda have minor children, there may not be a guardian appointed because there's a surviving parent. So there's a parent, as long as Wanda's alive, there may never be a guardian appointed. But this is really important to understand that there's a carve out for life insurance. But I will tell you, most people are advised by their family law attorney, unless you want your spouse to get the life insurance, you need to change it. And another thing is sometimes the court order requires there to be certain life insurance. And so this is very fact specific. And so when we write an estate plan, if you are divorced, your estate planning attorney should be asking for your divorce decree, and that lawyer should read it, okay? And that's really important. So that's something in our firm, we go through a process, and if you have been divorced, we're gonna ask for that divorce decree because we wanna make sure that we're not violating a court order when we draft the document. So that's really important.
Mm-hmm. All right. Also, by operation of law, the California Probate Code will, upon your completed divorce, remove your ex as agent on your financial powers of attorney and from your medical power of attorney or advanced healthcare directive. The completed divorce also severs any joint tenancy, so your ex won't receive your interest in the subject property if you pass away. And so I would say just be sure that your divorce judgment addresses all of your property, community and separate, so there is no question whether it's yours, whether it's community. You don't want anyone to say, oh, you omitted an asset. Now, years later, we have to go back and litigate this issue. You want everything to be covered.
And Winston, I think this is an example of, details matter, and these details are really important, and very small details can have an outsized result, like who gets that $1 million life insurance policy. So it's a big deal.
And one other point I wanted to say on that last slide was just because these things happen by operation of law does not mean you shouldn't also go to your bank and make these changes yourself. You absolutely should. You need to follow through on effectuating the division of property. So create new accounts, retitle your property. There are special procedures for retirement accounts. So don't just take money out of your 401k and give it to your ex. You need a special court order called a qualified domestic relations order, or a quadro. So just make sure you are following through on changing property and doing it the right way.
Yeah, because if you don't follow through, and what by operation of law means is, if Wanda is the beneficiary of Hal's bank account, by operation of law means that she is no longer the beneficiary, even though the paperwork at the bank says that she is. So if Hal doesn't get around to changing this, what's the bank going to do? They're just going to give Wanda the money when Wanda shows up with the death certificate. And that does happen.
All right.
So now what? So people are divorced. They say, yeah, my family law attorney. By the way, I'm just going to make one comment here. The divorce attorneys co-opted the term family law attorney. It's really the opposite. If you're getting a divorce, you're breaking up the family, for better or for worse, I suppose. But, estate planning attorneys should have gotten the term family attorney because, anyway, just a pet peeve.
I like that. So you are divorced. What do you do now? You should update your estate plan. You likely need all new documents. So you'll want to update everything to remove your ex, or maybe you don't, but most people will want to update everything to remove their ex. And now you have property orders, you can fund a new trust. So you want to change beneficiary designations on accounts such as retirement accounts and life insurance, except for what Jim mentioned earlier, unless you're prohibited by the divorce judgment. I have seen divorce judgments that require someone to keep their ex as a life insurance beneficiary for a certain amount of money, essentially ensuring that they get paid the spousal support that they're entitled to under the judgment. So within the confines of your divorce judgment, you should update everything that you can and follow through with retitling all of your property. And if your judgment changes your name, and in the divorce judgment form, there's a provision for whether or not your name will be restored. And so go ahead and follow through on that as well, to make sure your legal name matches what your judgment says it should be.
Yeah, this comes up not too often, but it does come up where people don't finish everything, okay, and they don't dot all those I's and cross all those T's. And it's much easier if you're going to go back to your maiden name, for example. It's much easier to do that in the divorce proceeding than it is later. You have to, I'm not even sure what you do if you get an order nunc pro tunc, or you just go through a name change. So it's a little bit more involved when you do it after your divorce proceeding is completed.
All right.
So let's flip it. Let's say, what if somebody inherits and then gets a divorce? So now what we're talking about is the kids, right? So now what we're talking about is not so much your assets and your estate plan, but this is where you're receiving it. So it's important, as I mentioned, assets in California that are acquired during the marriage are presumptively, or they are presumed to be community property. So what that means is if you acquire it during marriage, it's community property unless you acquire that property by gift or by inheritance, okay? Now, the problem is, you say, well, that's easy. I inherit some money, and I'll just put it in my joint account, and I'll just make sure I set that aside. Well, if it goes into a joint account, does that automatically make it community property? The answer is no. Can it be evidence of an intent to transmute to community property? Absolutely. And then I think sort of the last nail in the coffin is if you sort of put that money in the joint account and there's testimony that, yes, this person subjectively believed it to be community property, and you use that money to pay the mortgage on the house, for example, you're going to have a real problem. So what do you do if you're a parent and you say, look, I'm going to leave this to my kid, but I really don't want any future ex-son-in-law or ex-daughter-in-law inheriting, well, we use the inheritance protection trust. That's what the name we have given to a planning strategy that you as a parent can use in your own estate plan, so that when your child inherits from you, that inheritance is protected from divorce. That is designed to be protected from divorce, and it is far more probable that it will be held, that it will remain separate property with this structure than if you just put it in, even if you don't even put it into a joint account, even if you inherit that property and put it in your own name. So we have an example. Hal and Wanda pass away. Remember Hal and Wanda? Well, now they die. They have a daughter, Darla, and she deposits her inheritance into an account in her own name. Now, several years later, Steve, who's Darla's husband, the son-in-law, Steve, you see how this goes, D, daughter, S, son-in-law. Steve files for divorce. Steve wants half of Darla's assets. Now, Steve is going to allege in the family law proceeding that Darla told Steve, okay, right? Darla told Steve that she considered it community property and then used that money to pay bills. Steve can win with this argument, and sometimes he can't, right? But what I'm suggesting is this is a danger. So if you're a Hal and Wanda and you want to leave to Darla and you don't want Steve inheriting, then really consider proper planning, which uses an inheritance protection trust. Otherwise, Steve is going to end up with a fair amount of money. Do you want to talk about support, Winston, and how you inherit? This is not so much a division of community property, but this is if you have a divorced child, for example, and you leave that divorced child assets. Let's talk about how this affects support.
Yeah, and I will say it's very case specific, fact specific, but this is out there and it's real and it does happen. So what happens if you receive an inheritance after you are divorced? And it can potentially affect your support orders. When the court is analyzing what support should be set at, a person's needs and their ability to pay are factors that the court considers when setting support. So inheriting a large sum of money is going to affect your needs and it's going to affect your ability to pay. And if those factors were important to the court, support would have been different, but for this person's ability to pay, or support would have been different, but for this person's needs, then inheriting, even though it's separate property, it's not subject to division, it is still relevant to support. There are also support orders that provide for additional support to be paid for money received in excess of your base salary. So sometimes people have a base salary, but sometimes they get bonuses. Your support orders can factor that in. And it's going to really depend on the language of your support order, whether or not an inheritance is relevant to that. But I have seen it, and it's something to be aware of.
Yeah, and so I think, our job is not to overcomplicate things, but our job is to realistically assess your situation. So if for those of you who come to Cunningham Legal and we meet with you and you say, look, I am divorced and I've got these issues, or my son or daughter is divorced and I'm worried about it, or they might be divorced, we go through these brick by brick in the sense that it's very detail driven and detail oriented. And it does require an expert, frankly, an expert lawyer. So this is not the area for generalists. You need to assemble your A team, which we'll cover that toward the end here. But what do I mean by that? You need to have a great lawyer. You got to have the CPA, the financial advisor, all in sort of at the same table with you going over your estate plan. So after Steve and Darla finish their divorce, Darla's Aunt Abigail, good old Aunt Abigail, leaves some money to Darla. And the court had looked at Steve and Darla's needs for support, and they put in there, if Darla gets any more money, then even if it's separate property, that's going to affect her ability to pay, and Steve still has his needs. And so what happens if Darla inherits a chunk of money, Steve's support may go up. So some of Aunt Abigail's inheritance to Darla is going to go to Steve. And then certainly if Darla dies without updating her estate plan, even ex-spouses, right? If there are no kids and no other intestate heirs, an ex-spouse is in there kind of behind cousins, right? But they're in there. Now, it's possible that if you come from a family, and I'm an only child. If you have an only child and your parents were only children and your grandparents were only children, you may have a really small family. And in that circumstance, it is possible that the ex-spouse, even after divorce, will end up with assets. So kind of crazy. So Aunt Abigail could have protected Darla with proper planning. And again, that's typically the inheritance protection trust. That is where Darla is in control of her inheritance, but it is protected from creditors and additional support orders. So what are some key takeaways from today? As the wise commentator Yogi Berra once said, it ain't over till it's over. Just because you file for divorce doesn't mean you are divorced. And again, I mentioned everything sees the light of day. If you're going to try and do some shady stuff or hide this or hide the ball there, I will tell you everything does see the light of day. You cannot go to a lawyer and say, hey, lawyer, I've got this court order. How can we get around this court order and violate it? No attorney's going to help you with that. No reputable attorney will. Just because it starts out as separate property doesn't mean it won't become community property, okay? It is almost impossible, Winston, for property to go from community to separate. You have to really make an effort to go from community to separate. You have to engage separate lawyers. There's this whole process. But separate property to community property, I mean, it can happen inadvertently.
Happens all the time.
Yeah, right. Again, details are everything. Seek out an expert. Do not ignore your estate plan after divorce. So that's one thing. A divorce, for some people, is liberating, quite frankly. For other people, is catastrophic. It is rarely, I don't know, Winston, has there ever been a pleasant divorce? I think people are in a little bit of shell shock after a divorce, and you may be inclined to ignore your estate plan, but please don't ignore it, okay? And then this is the A-team. So you need to assemble your A-team. And who are you, Winston?
The only one I know is Mr. T, so I'll take that.
All right, Mr. T. All right, I think I'm the guy with the cigar. So it's your lawyer, financial advisor, and CPA form a three-legged stool. That is George Peppard. Yes, I know who George Peppard is, for those of you watching. And this brings us to the end. And we do have a couple of questions. Go to our YouTube page. Check it out. Lots of YouTube content on there. Lots of videos. Lots to learn. And then if you would like to set up a time to speak with us, you can go to our website and click the button Request an Appointment. And again, if you're watching this on YouTube, please don't forget to subscribe and share if you think this is content is valuable to other people, and review us on Google. You can go to Google and give us 5 stars. We'd appreciate that. So we do have a question here from Anita. Anita says, what about a person living with a person but not filed with the state as a domestic partner? What should they do to protect their intent upon their passing? Anita, that if a person is living with another person and they're not married and somebody dies, title controls. Okay, so if you don't have any assets with that person, then that becomes part of your estate. If you have a living trust, the property is distributed in accordance with the terms of your living trust. But if you are not a registered domestic partner, which is a form you fill out with the state and submit it, and you're put on a list of people. If you do not fill out the registered domestic partner form and register, then you are cohabitating, and there's no relationship, okay? It's a little bit different when it comes to family law, and this is the Marvin versus Marvin, the Lee Marvin case. That's if somebody is living, you have a couple living together and one spouse tells the other spouse, oh, don't work and I will take care of you. That may be what you're concerned about, but in the case of death, it's just a person who is cohabitating. Now, what's interesting about that is how do you provide for that person? Well, it is not uncommon for in an estate planning setting where you have 2 people who are cohabitating. Perhaps one person owns the property, and when that person dies who owns the property, they can set up a right of occupancy for the partner. And that can be for a term of years. It can be for 6 months, a year, or life. And what we do is we go through, in that situation, we get very detailed on who's responsible for the upkeep on the home, because that can be a really difficult situation if you've got kids who own the home, but then you might have a partner who's got a right to occupy the home. How do you do repairs and bills? So Julie writes, we are beginning the divorce process and creating an estate plan. Husband thinks his opinion of values is adequate. I think everything should be evaluated. Is there a law or requirement that establishes value of assets? So that's a divorce question. I will defer to you. any thoughts on the valuation of assets in a divorce setting?
So there would be a couple ways to go about that. One would be, and then we're talking about, not accounts, because you can determine the account value of the date of separation, not real property. So for real property, you can either get an appraisal, or in theory, you can agree to the values. And that's where I was heading with this question. I'm assuming you're talking about not accounts, not real property, but more, maybe personal property or other property. You can agree on the values, or if you don't agree on the values, well, then the court can determine what the values are. And so you would say, I think it's X, he would say, I think it's Y, and then the court can assign that a value. And you can, introduce evidence supporting your position. But if you can't agree on the value and there's not, an appraisal, the judge will decide.
Yeah, and I think that's interesting in the context, if you own a business or a law practice, for example, when a lawyer gets divorced, they value the law practice, and that because at divorce, unless there's a prenuptial, community property is divided 50-50, and then you have the issue of support. So valuation is important. But I think that brings us to the end. I want to thank you for joining us today, and please check out our YouTube page. Lots of great content there, and have a great day.